This language takes care of that, because we talk about specialty, and it is the written protocol of what the physician who's licensed in Georgia gives that person.
Thank you, Representative Burmeister. Again, the concern is when we address these issues, it seems, Mr. Chairman, that the picture that's painted both by advanced practice nurses and physicians is the current context in which they're operating, which is in a clinic under the daily direct supervision of a physician. They serve as an extension of that physician. In some cases, there might be remote clinics where they can operate. The concern that I think we're looking to address, that I think is a real concern, is that as we draw these kind of the boundaries of the playing field, if you will, that we not allow provisions of this to have unintended consequences, i.e. a circumstance where there could be a physician who's licensed in the state of Georgia, doesn't physically live in Georgia, and serves as the, quote, supervising physician of a large number of advanced practice nurses in everything from clinics to drugstores. That we strengthen the language to make sure that there's no way for that to happen. And I think
then you need to do that, pardon me, then that needs to be done under the medical code, under the licensing authority, and not in a very narrowly drafted bill that addresses one subject and one subject only, and that's to codify into law that the advanced practice nurse, under the supervision of a protocol agreement that is written with a physician, can write, but they can currently call in.
Mr. Chairman, I'll just close by saying, this section by saying, my concern, Representative Burmeister, and I want to find a way to make this bill work, and I appreciate very much what you're doing. I'm just not comfortable the language in your bill draws narrowly enough those parameters, and in the amendment we've got proposed, I think does that. If you think it oversteps, I'm willing to go through piece by piece and kind of perform surgery on our proposed amendment, but I'm not going to be comfortable supporting the bill until I feel like we've drawn the boundaries where they need to be, and I want to find a way to support your bill. So, Mr. Chairman, I'd yield to some other members of the committee.
Thank you. Was there another question for Mr. Burmeister? Mr. Mack.
Great presentation. I see this language is talking about every 3 months versus 6 months.
That's not my bill.
In practice, what is going to be? Do you have an opinion as to whether or not what impact that will have on the? I presume that that's being offered by those who are not really concerned about liability, but one of the things we're thinking about is what impact would that have, if any?
I do have an opinion. Currently, they are required to have their protocol written agreement between the physician and the APRN. That is reviewed every year. And I think we are overstepping and asking the physicians to take on a tremendous amount of additional paperwork when we're calling for every 3 months for controlled substances and 6 months for at least every 6 months any patient receiving control. I guess they want to see the patients. I guess that's what I'm reading into this. Maybe that patient wants to see an APRN and not a physician, and the physician is very happily. I'm talking about maybe hospice care, and hopefully those people. Does a physician want to go out to their home or into a nursing home or whatever kind of hospice care facility that might be offered? Does a physician want to do that? I don't know. That is, I guess I'm saying that piece, if that's what the medical authorities want, if that's what physicians want, then I think that should be addressed in the physician's, the medical act, rather than a nurse protocol. current agreement, which we all know most people are very, very happy with and don't want to see it changed.
All right, are there any other questions? If not, now we, in the interest of time, I do want to give the representatives of the PAs an opportunity to speak to either one of these bills. Please come up and do that.
Thank you, Mr. Chairman. My name is Tom Bauer. I represent the Georgia Association of Physician Assistants. Appreciate very much the opportunity. I was at the hearing the other day, but none of this came up. And let me first say, Mr. Setzer, I appreciate your concern and your suggestion. One would only partly get there, but I do appreciate it. One of the things that
before this substitute would be ready for prime time before the full committee. I am comfortable considering this substitute as refined in the full committee, but as I've said, I'd like to see, I've said to folks on this committee and I've said to folks who have visited with me on this issue, I would like to see it move along, and so I'm willing to move a due pass recommendation to the full committee on 1218S.
All right, and would that include the amendment that?
I would ask that that does include that,
And
yes.
that is, where is that amendment in there?
The amendment language I would like to put in there, and I would have to defer to Ledge Counsel or something to see exactly where we need to include that in my bill, exactly what line. But line 31 through 35, page 2, it's that subparagraph C, which will not, it makes it unlawful for any managed care, health plan, hospital, insurance company to require a physician and a nurse to enter into a protocol agreement in order to be reimbursed by those entities.
Now, the only problem with that is that that's a completely separate chapter of Title Code.
I'm sorry, I just don't know where you're proposing the amendment.
Well, I don't oppose that language. I was trying to actually appease Representative Setzler with some language that I don't find offensive in any way. But I do not know where to put that in my bill. I don't.
You're talking about, I think you're talking about the other bill, you're talking about against any such order. That's not what I'm talking about. You said that there was a typographical error.
Oh, I'm sorry. Okay, I'm sorry. Yes, the typographical error would be on page 2 of my bill, LC 331218S. And if you look, it says 1, execute A, then put in verbal, comma, written.
What line are you on?
19. Just put the word verbal, comma, after A.
Execute
A, verbal,
written,
comma.
or electronic.
Yeah, put a comma after verbal, so it's verbal, comma,
You
written.
set that as a, execute a verbal, written, or electronic order.
Yes.
Yes.
At square time, I call for the reading ordinance for the motion to use a table since there can't be promised a vote.
some brief discussion on the motion?
I'm not sure that we had discussion on a motion to table.
Okay.
All right. Parliamentary inquiry.
I'm not sure this is something that, the way I interpret the motion is on the table for the
I'll have to leave that, as the speaker says, I'll leave that to the judgment of each and every member of this committee.
further inquiry, Mr. Chairman.
Yes.
Is it not true that we've had something that could be effective to satisfy the concerns of members, even at the committee of the whole, that must meet after this subcommittee?
That's right. This is, as I have told everyone who has testified, this is a subcommittee, and I probably shouldn't say it again, but I'm going to. It's kind of like kissing your sister in some ways.
Don't say that before.
Whatever could, yeah, I'm in the
You know what bill is coming up next?
But I do want to say this, that whatever is done by this subcommittee can certainly be reconsidered and perfected in the full committee. So, having said that, that is my opinion as chair of this committee, that it will simply go to the committee and essentially begin anew, fresh. So there is a motion to table parliamentary inquiry. Go
Would
ahead.
such a motion also be appropriate with the full committee, Mr. Chairman?
To
To
table?
table.
Certainly, that could be made at that time, when it gets there. All right. There is a motion. All those in favor of tabling LC 33-1218S, that would be Ms. Burmeister's bill, please raise your hand indicating that you favor. 1, 2, 3. All right, it appears that that motion has failed. That motion having failed, the motion to do pass LC 33-1218S is been made and seconded. Is there further discussion on that?
Mr. Chairman.
Yes.
I just want to make clear to the committee, if I could, that I've got grave concerns with the bill as it's presented. I do very much appreciate Representative Burmeister's offer to, include language from lines 31 through 35 on page 2. I don't think this bill, from a policy standpoint, jives with the policy expectations of members of the subcommittee. We can pass it on, but I don't think that's. I think from a standpoint of throughput and getting this bill moved through the House and to the Senate and made into law, I don't think there's any significant advantage to passing on a significantly imperfect bill. That being said, I'll
Everyone on the same page.
This is
Just get everyone on the same page. But I don't want to see the legislation itself.
my concern is what happened was we just made a motion. We just swayed the.
I'm not. I'm not swayed by that.
No, but what I think we see is we're going to see the nurses emboldened to dig their heels and not want to make deals. I will just
to call this meeting to order. If I could have your attention, please, we're going to go ahead and get started a good bit later than we had anticipated, but we had the other subcommittee. Let me just sort of tell you where we are, what we're going to be doing. First of all, welcome to, oh, thank you. I thought this was to be on all the time for me. Got to fix this, Mr. Leader. It will be now, okay. This is about the 6th hearing that we have given to this piece of legislation. We met for an extended period of time last week, and the majority leader and his counsel, Mr. Choate, were kind enough to spend a lot of time with us answering a lot of questions, and even though we sort of started working through the bill, we actually got into other parts of the bill. So what we're going to do today, I'm going to begin in just a moment by recognizing the majority leader to continue to the extent that he desires with an explanation of House Bill 1059.
Bless you.
As it's appropriate, we'll obviously be recognizing members of the committee for questions. We will not be taking public input. We've had at least 2 hearings in the past where we've had public comment, and then we've gotten a substantial amount of written comment, which has been very, very helpful and has, in fact, resulted in modifications to the legislation, except to the extent that members of the committee specifically desire that. We're going to try to conclude this afternoon by no later than 5:45, so I'm going to kind of tell you that's the box that we're working in. With that, and Josh will help me with the microphones up here because we're not, this committee's not used to this ornate a setting and with its technologically advanced setting. So with that, I'm going to recognize the majority leader and anyone he would care to have assist him in continuing with an explanation of House Bill 1059.
Well, thank you, Mr. Chairman. Ladies and gentlemen of the committee, it's just wonderful to see you all again.
Now, you don't start by lying to me.
I was not under oath, Mr. Chairman. But I sincerely want to thank you for your indulgence last week. I was, to say under the weather was an understatement, and you were most kind in allowing me to cough and sniffle and hack through, and I sincerely thank you for that. Given the chairman's instruction on time, I'm going to, with your permission, Mr. Chairman, sort of jump in with some changes automatically because a lot of the discussion we had at the last meeting centered around this, and I believe we have an amendment here which I'm hopeful that will certainly answer those questions and concerns by the committee members, and I believe makes it a better bill. If you would refer, and I believe, Mr. Chairman, the members have it in their folder, AM 290449. That is Amendment AM 290449. And what we're addressing here is the concern of taking someone who was first offender, not the circumstances of the crime were certainly not aggravating, and finding a way to make sure they were not subject to the minimum mandates. And the language before you today is an attempt to do that. If I can refer you to that, as you can see at the beginning, all those are definitions that I believe, counsel, are identical in terms of the definitions of what the sexual crimes are. But if you go down to line 30 on page 1 of the amendment, it says, in the court's discretion, the court may deviate from the mandatory minimum sentence as set forth in subsection B of this code section or any portion thereof, provided that. So what we're saying that the court then would have discretion to deviate from the mandatory minimums. And then it goes on to say on page 2, it lists that, first of all, if the person has no prior conviction in this state or in federal court or in any other state of a sexual offense. The defendant did not use a deadly weapon or object, device, or instrument which was used offensively against the person. The court has determined that similar transaction evidence does not exist. The victim did not suffer any physical harm or visible body harm. The victim did not involve asportation, or the offense did not involve, asportation of the victim. The victim was not physically restrained during the commission of the offense. Now, under those exceptions, then it would allow the court, the judge of that case, to step outside of the minimum mandates and sentence as the bench certainly felt compelled to do. And, Mr. Chairman, I hope, and if we want to discuss that now since that amendment's on there, that addresses probably 70% of our previous discussion, and hopefully with the discussion of this amendment, and I would hope I hope a committee member would move its adoption, that we could maybe help answer some questions.
Mr. Leader, it was the committee, I think, was concerned last week about having a victim veto, as it were, probated sentences. Is it fair to say that this amendment eliminates that scenario?
It does indeed, Mr. Chairman. Thank you. All the language alluding to the victim's ability to veto or not testify has been removed from the bill, and this amendment replaces that language with this particular provision. Mr. Chairman, I also would like to say that I know Mr. McDade with the District Attorney's Prosecuting Attorney Council is here, and I don't portend to speak for them, but his comments to me were not only do they support this amendment wholeheartedly, they are now in support of the bill as it's drafted with this amendment in total. And I'm not trying to speak for Mr. McDade, but if you would allow him, he may comment to that as well.
Very briefly, Mr. McDade, is that correct?
Yes, sir.
Okay, thank you. Questions from the committee as to the amendment? Vice Chairman Mumford.
Under Section E, the offense did not involve asportation of the victim. Asportation can be defined as any movement of the victim whatsoever. Did you have in mind under E something to the general effect that the victim was being moved from place to place, or asportation is a term that's we often see in shoplifting when you pick up an item on a shelf with the intent to steal it and move it even a few inches. That's the definition of asportation, and that's the element for shoplifting. Was that the intent, even a movement of a few inches here? What are we trying to get at here with E?
I'm going to let counsel who helped draft this explain that, but that would not be the intent of a few inches, obviously.
Perhaps transportation would have been a better word, but the intent is that there was no carrying away from one scene to another, no attempt to transfer. Perhaps something that might be less than kidnapping, but what the court might consider an aggravating circumstance and render the commission of the crime not susceptible to a deviation from the minimum mandatory.
Further questions from the committee as to the amendment? Chairman Bordeaux.
Thank you, Mr. Chairman. Thank you to the majority leader. I appreciate y'all showing me this amendment before we started and letting me look at it. Let me ask you about on page 2, line 7. The court has determined that similar transaction evidence does not exist. How would you foresee, how do you see that happening?
Mr. Bordeaux, the intent there was that we use a defined term, similar transaction evidence, that has been well defined through the cases, so that if the court found that there was evidence of similar occurrences involving this particular defendant, and I think under the legal definition of similar transaction evidence, the court would have to make a finding of relevance. If the court found evidence of relevant other activities similar to this, such that it would be admissible in evidence for a jury to conclude that that might indicate that the defendant had committed this crime, then that would render this person incapable of receiving a deviated sentence. I might add that these are patterned after, although not word for word, from the federal sentencing guidelines that allow federal judges to recede from and deviate from the federal sentencing guidelines. So that's the intent, is to have a recognized legal term that we don't have to argue about. Every lawyer knows what it means. But if the court finds that, then maybe you don't have a prior sexual offense, but if you've engaged in other occurrences like this, then perhaps you're not a person we should consider probating.
If I may continue, Mr. Chairman, I guess I should break this down into two parts. One is about similar transaction evidence. When I was in law school, we were told that similar transaction for evidentiary purposes was where, and I remember this specific example, that if there was evidence that a defendant robbed a gas station, then called a filling station, wearing a suit of armor, and there's a similar transaction where somebody else on 3 different occasions robbed a filling station wearing a suit of armor. That was deemed to be a similar transaction. And in the 100 years since I got out of law school, it's come to mean something much wider and much less stringent. Would you agree that if I guess for some of these crimes, if a battery, for example, if the defendant has previously, if a male defendant has previously struck a woman, could that be a similar transaction?
I don't believe it would if you're talking about similar to a sexual offense. It would. Now, if the offense were perhaps sexual battery or aggravated sexual battery, then I think yes, it would be. But if it were incest, for example, or perhaps something else, it might not be.
I guess that is my question, because, for example, one of the crimes we're talking about is aggravated assault with intent to rape. If the defendant has a previous conviction, but evidence of striking a woman previously, whether it's 20 years earlier,
yes, sir.
As I read this, he would not be eligible.
If the court looked at that, and if our intent here is for the court to be able to look at a similar transaction, and if under the fairly well-defined law dealing with similar transactions, the court reaches a conclusion that it's relevant, and therefore, were this a trial in the guilt phase, that evidence would be admissible to show bent of mind, a motive, that's conduct consistent with prior activity, then yes, that could preclude a deviation.
If I may call
Yes.
a couple of last questions. The second part of my concern about this paragraph C, I guess, or item C, is that we don't talk about evidence that was introduced at the trial. We don't talk about evidence that was introduced at any time. We ask the judge to make a finding that no such evidence exists. Would you be comfortable with changing that to something like, for example, the court has determined that no similar transaction evidence was introduced in the trial of the, for which the...
Well, this is prior to the trial.
Well, it could be after.
Oh, that's right.
Yeah.
Do you understand my concern? I'm not trying to split hairs, but we're talking about something existing versus evidence that was introduced.
Well, I think the purpose, as discussed about putting this in, is that first you have to find that there's similar transaction evidence. Similar transaction evidence would be evidence that the court found met the criteria for admissibility as similar transaction. If the court doesn't find that, then it per se does not exist. So if the court does find that evidence of a similar transaction is relevant and would be introduced in the guilt phase, then it does exist. So and understand this may very well be a situation that is dealt with at a sentencing after a plea, and probably be the subject of negotiations prior to a plea. So the idea is to make sure that just because there's not a conviction, if we've got a guy out there who's a really bad actor, then perhaps we really don't want to deviate, even though this is the first offense. Because frequently we find out in dealing with people who've committed sexual offenses, that the first time we catch them is not the first time they've done something. In fact, there's some really sort of scary numbers out there that people who get caught have done this 50 or 60 times before they actually get caught. So what we're trying to do here is to make sure that the guy who has not done this before, who's not made this a sort of course of conduct, he's just been fortunate not to get caught, that fellow has consideration, or that gal has consideration. But if we've got similar transaction evidence, then we really don't want to create a probationary situation. That was the intent of the language and why it was in there like that.
I can just see situations, though, again, going back to take the first crime, aggravated assault with intent to rape. If that defendant has, if evidence exists that he assaulted a woman 10 years earlier, that could be evidence of a similar transaction. It wouldn't get into whether he had a justification for assault. It wouldn't get into any violence she had, whether he was guilty of assault previously. You're, as worded, and that's what we've got to go with here, you're talking about evidence of an assault of any sort, regardless of whether it was justified.
Yes, sir, if the court deemed it relevant, and I think that's the responsibility for making the determination in this is with the court. And what we were trying to do was to repose that sort of decision-making in the court as opposed to giving it to the victim or giving it to the district attorney. But here's the criteria. If this person has done something, but your example is exactly correct, yes.
Further questions from members of the committee as to this amendment? Chairman Knox.
Am I lighted up? Am I light on? Mm-hmm. Okay. Now, do I have to turn this thing on now?
Yes.
It's on? Okay. Just on this same point, not to belabor it, but I think I heard Representative Bordeaux concerned about whether or not the judge can even make a decision about whether there is evidence that exists. There may be evidence out there that hasn't been adduced at any kind of a hearing. The person hadn't been arrested on it, hasn't been charged with it, nothing. But it does exist. He just isn't aware of it. That's a whole different matter. So it seems to me like what we're really trying to say is that the court makes a finding that there is relevant, either makes a finding or doesn't make a finding that there's relevant similar transactions, that there are relevant similar transactions. And that's probably basically all you need to say in that particular sentence. And because otherwise I'm afraid you won't be able to enforce this with exist. I think it's just too broad to be able to make it fly.
Chairman Knox, if I understand, I think what you're saying is if you added the word relevant in front of similar. Is that what you're saying?
Yes.
Certainly, I don't have any problem with that. I mean, ultimately, the way this is written, it is up to the court or the judge to rule, given the judge discretion to look at the evidence and make that determination, which is certainly, as you know, the case in most trials. But if that raises your comfort level, I certainly have no objection to that.
Well, I guess the point I'm making is if it says this, the court has determined that relevant similar transaction evidence has not been found. That's a much better, narrower standard than saying that it exists, because it could very well exist and you just don't know about it. The judge doesn't know about it. You don't want this to come back to haunt you later. You want this over with when you make this decision. And so I'm just saying that I think it would be better if it just says relevant similar transaction evidence has been found.
Everybody okay? Okay.
Has not
Does that
been,
work all right?
Has not been found.
I beg your pardon, yeah.
All right. The court has determined that relevant similar transaction evidence has not been found.
Right.
Okay. Further questions from members of the committee as to this amendment? Hearing none, and before I ask you to go forward, Mr. Lord, were there others? Okay. Before I ask you, okay, let me do one thing before I recognize you. I wanted just to recognize a very distinguished guest we have with us today, and that's the judge of is it the judge of the week now or the day? Judge du jour.
Sure sounds like a long time.
The judge of the day or longer is a former member of the old House Judiciary Committee and one of the finest members of the legislature that I had the pleasure in my 10 years of serving with, now Judge Mike Boggs, and we want to welcome you to our committee, Judge Boggs.
Mr. Chairman, if I could add to that, why Judge Boggs was a member of this body. He introduced legislation regarding sexual offenders, and I have sought his counsel on this and appreciate his stance since transferring to the bench. He's been a great advocate.
Mr. Leader, would you continue, please?
Yes, there is another amendment in your package. This one is AM 290443. I'll let counsel. This refers to the bill, and again, just as a point of reminder, not only to the committee but myself, we're working off LC 292137S, which was the same draft we were working off last week, I believe. Yeah, and this, does everybody have the amendment? And this has to do with line 8 on page 22.
Members of the committee, this is sort of in the form of, again, belt and suspenders. This language is in the in Title 42-112, the sexual registry, and it makes it clear that conduct which is punished for a misdemeanor or which is prosecuted in juvenile court will not be subject to the sexual registry. If you'll recall from the discussion last week, we have created misdemeanor treatment for misdemeanor treatment has existed for statutory rape for a long time. We've created that the same or parallel treatment for sodomy, and for sodomy as an aggravating offense for aggravated child molestation. So this is to make sure that teenagers within those years that are accused of those crimes, if they are in fact handled in the Superior Court system, they'll be dealt with as a misdemeanor. They won't have to register as sex offenders, or if they go into the juvenile system, which most of those would anyway, they wouldn't be handled as a sex offender. So this is just to be absolutely sure that we capture that group and exclude them from the registry.
Okay. Before I invite questions as to that amendment, my apologies to my good friend and Vice Chair Representative Mumford, who had a question about the prior amendment. So I'm going to go back.
I'm going to morph it into both.
Okay. You have that privilege.
Just for my benefit, would you please sort of lay out an overview of what the more serious offenses are, what the less serious offenses are, and what the punishments are for each under this bill, going back to the previous amendment, and I hate to, maybe I'm belaboring.
There are two types of, roughly speaking, you can look at sexual crimes in two areas. There is the, under current law, minimum mandatory sentencing, and that applies to rape, kidnapping, aggravated sexual battery, aggravated sodomy, and aggravated child molestation. The only change we are making in the way those are treated is that the minimum mandatory is being raised from 10 to 25, and that upon completion of whatever period of time is served, 25 or more, those people will be on probation for the rest of their life. The philosophy there is that those are more likely to be the sexual predators, the repeat offenders, and the state needs to keep a hand on those people.
Watch your nomenclature. They're not really on probation. They're on report.
We've used the word probation. We suspect, and once again it'll be difficult to be precise at this point, we suspect that when those offenders, as all sexual offenders now will be reviewed by the board, they will more than likely fall into the category of predators. And in addition to being on probation, they will be monitored. That is the group that will be monitored, those that are determined to be a sexual predator. The other sexual offenses are those that are laid out, and that particular sentencing provision is contained in Title 17, Chapter 10, Section 6.1. We have come in behind that and created a new Title 17, Chapter 10, Section 6.2, and that is what the First Amendment deals with. That is New Code Section 1710, 6.2. It deals with aggravated assault with intent to rape, false imprisonment if the victim is not the child of the defendant and the victim is less than 14 years of age, sodomy, except for the misdemeanor exception for the Romeo and Juliet, statutory rape if the person convicted of the crime is 21 years or older, child molestation, enticing a child for indecent purposes, sexual assault against persons in custody, incest, a second or subsequent conviction of sexual battery, sexual exploitation of children as defined in Code Section 1612-100, and that's the computer crimes, the enticing through the use of a computer. Under those, for that laundry list of crimes, whatever the minimum sentence there is, it is made by subsection B mandatory. In addition, this parallels Section 6.1 because there is no probation, there's no first offender treatment. Once again, the underlying concept was that sexual crimes are such that first offender treatment doesn't make sense because you essentially pretend it never happened, and that's not a smart thing to do with regard to people who've committed sexual crimes. Then you get down to subsection C, which does not exist in 6.1. There is no power in the Superior Court to modify the sentencing under 6.1. However, there is within 6.2 and the crimes we enumerated, and those are the criteria we have been discussing. Now, the other piece of this criminal section is the Juvenile Code, and I was sent back to the books this weekend to look at the Juvenile Code, and what I found is that except for the 7 deadly sins in the Juvenile Code, which are otherwise referred to as 440 cases, in Title 15, Chapter 11, Section 28B2, all cases involving children under the age of 18 are exclusively in the juvenile court. Now, if you are one of the 7 deadly sins, you immediately go to the Superior Court. Once you get into the Superior Court system, you have a pre-indictment. The district attorney can refuse to prosecute in the Superior Court and can refer back to the juvenile court. After indictment, upon motion or sua sponte, I imagine, the court can also send a juvenile, even one charged with one of the 7 deadlies, back to the juvenile court system if he determines it's possible. After conviction, if you're convicted...
I'm not sure that's correct. Are you sure about that?
Yes, sir. Yes, sir. That would be... Yes, sir. Yes, sir.
The judge can make that determination on motion of either party.
Yes, sir. It says the court may, upon finding certain circumstances, transfer the case back to the juvenile court system. That's 1511-28B2 D-C, I believe. After conviction, if a juvenile is tried in the Superior Court for one of the 7 deadly sins and is convicted of a lesser included offense, then that is sent back to the juvenile system automatically. There are some additional provisions where juveniles can be transferred back up, but the only crimes that we're concerned with here today that they would apply to would be rape. So that's in a fairly broad way. That's the way we sentence these crimes. That's the way they're currently done. This is the way we're contemplating this. The real change is not in the definition of the crime. The real changes in this bill are the lengths of the sentences and the creation of a mandatory minimum for these other crimes. And subsection C in the amendment is the provision for the courts to be able to probate in limited circumstances people who commit these other sexual offenses that are not one of the deadly 7.
Yes, Representative Mumford.
Sexual assault against persons in custody carries what today?
It differs. The only thing we've changed in there is with regard to sexual assault against children under the age of 14. We've made a minimum 25, a maximum 50. none of the other sentences have been changed. It's 1 to 3 years for those on parole, custody of law, hospitals and schools, and 1 to 5 for long-term care, personal care, home health care, and hospice. We haven't changed that. We've only changed with regard to the age of the victim, we've increased the punishment. I might also add that there is a change in the definition of physical contact at the request of the district attorney's office based on some recent cases that they've had. And we've discussed that with Mr. McDade, and I think those changes meet his concern.
What are those changes about the? This is a real concern of mine, because I'm very concerned that we've got a lot of school teachers in our state that are sometimes falsely accused of this particular offense, and if they're facing 25 years for touching a child under the age of 14 inappropriately, I can't imagine why anybody would want to be a school teacher in the state of Georgia.
Mr. Chairman, could Mr. McDade address that?
Mr. Chairman, the change in language dealt with the definition of actor and intimate body parts currently with inmates and their custodians. If one person's intimate body parts was involved, it was a crime. And we have cases where inmates are performing sexual acts with guards and guards performing sexual acts with inmates. The definition of actor limited it to his or her intimate body parts, i.e. the guard. We simply expanded the definition of intimate body parts to include either person. Didn't change the responsibility of a school teacher or the guard. You said if either person's intimate body parts involved, it's criminal. The definition of intimate body parts stayed the same.
Well, let me ask you this, Mr. McDade, to make sure I understand this. If we've got a school teacher who is convicted of fondling the breast of a 12-year-old child while he's adjusting her ROTC uniform, he's subject to a 25-year mandatory minimum?
Under your scenario, I don't believe he would be convicted. Under your scenario, I don't think any jury would convict him if that's actually what happened.
Well, actually, that's the case that caused sexual assault against persons in custody to be written, because I wrote the statute.
I would simply suggest to Representative Mumford that if that were the facts, I don't believe that a jury would convict if that were the whole facts.
Well, in fact, they convicted a simple battery in that case because sexual assault against persons in custody didn't exist.
I can't argue the point.
On my facts, would they be subject to a 25-year mandatory prison term under this section?
Yes, if convicted.
Just for touching?
No.
The breast or buttocks?
If it's a sexual contact, yes.
Sexual assault, touching the breast or buttocks of a child under the age of 14.
Well, the code section, and I'll defer to you because you wrote it, but it says assault. So assault that involves a touching is an unauthorized touching that has more than just an innocent connotation, and that's a question of fact for a jury. I would agree with Mr. McDade that a jury would have to find that it was not, in fact, an innocent touching, that it was intended to be a sexual contact, and perhaps the innocence was the defense. But if the jury found that there was no innocence, then they'd be convicted of the crime.
All right, so the response is that nobody would get convicted under those circumstances, so don't worry about the 25-year sentence for school teachers.
Well, there was I personally would not worry about a 25-year sentence for a school teacher who fondled a 12-year-old against a 12-year-old's will. No, sir. I don't have a problem with that at all.
Representative Mangum, and we're on Amendment 0443 at this point. Representative Mangum.
Thought I was feeling better about this bill until I started hearing that. And just to follow that up, because my understanding, again, I'm not a criminal attorney, and let me understand the purpose behind this section in light of what my colleague just indicated, because my understanding of sexual assault is if I am adjusting the ROTC uniform, the bra, whether I'm a female or a male, and the kid who is under 14 is upset with whatever, or whatever, she basically lies and says, I touched her inappropriately. An assault is an unauthorized touch. Is that correct? Am I right about that? So that would put an undue burden on a teacher. And of course, we don't need teachers to touch inappropriately, but these days, we have a discipline problem in schools. And we don't want a teacher to be on the defense all the time, and I'm concerned, because I thought this section was saying something else, because I haven't read it all, but just got it. But this section I thought was providing for the court having to in their discretion, probate sentence. So, but there's either a mandatory 25 or the court will probate. Is that the two? We're going from 25 years?
Representative Mangum, we're sort of, if I could stay with the sexual assault in custody, there is, and I'm sorry I didn't mention this in my response to Representative Mumford, there's also a requirement that the touching be for the purpose of sexual gratification. So that's a prima facie, that's a part of the prima facie prosecutor's case. And I think that is a pretty high standard to prove. And but we haven't changed the law in that respect a bit. And what we have done, though, as we talked about before, is one of the prime purposes is bills protect children. And if a school teacher touches a 12-year-old on her breast for the purpose of sexual gratification, then they've committed the crime of assault against a person in custody. And because of the age of that child, the policy decision that the author made is that that person should have 25 years in jail. Now, if that's the first offense and the other criteria we've met have been made, never touched another student, has no prior convictions, no asportation, didn't try to take the child anyplace, didn't hurt the child, no deadly weapon used, then that person could be, in fact, be probated.
If I may, Mr. Chairman.
Yes, Mr. Leader.
Representative Mangum, I think prior to you arriving at the meeting today, we went through the amendment 0449, which outlined the provisions. What were not in the bill last week is an amendment which allowed for, under your example, if this was the first offense and the items listed on page 2 of that amendment were in place, and I think Mr. Knox may amend the wording of C, I believe it is, then the judge would have the discretion. At that point in time, the court would have the discretion to sentence outside of the minimum mandate. And let me speak, you say you're not a criminal attorney, but I know you're a member of the bar, a learned attorney. I'm not. But let me say from a policy standpoint, if we have someone teaching in our schools, and this is not the first situation, and the evidence meets the definition of the law, and they are convicted by a jury, from my standpoint, that's someone we do not need in the school system, and I think is shown a propensity to commit offenses against children.
Further questions by members of the committee at this time? Chairman Bordeaux.
Yes, sir. Thank you. I'll try to be brief. Help me understand the overview of the bill. Does this involve murder at all? In other words,
No, sir.
Right. And am I correct that murder being one of the 7 deadly sins, the minimum mandatory for that is 10 years? Or is that life?
I believe life imprisonment is the minimum sentence for murder.
Is that correct?
Correct.
Life.
If you're sentenced to life, can you be probated after 10 years? Is that how it works?
No,
When can you be probated on murder?
you cannot be probated for life. You can be paroled. That's what the section is talking about.
After how long?
So the parole board, but you're eligible for consideration at a certain point in time.
After how many years?
14 is, I believe, the current standard. Some say 7.
Okay. So if just to sort of get the big picture on this, if I murder that child, I'm sentenced to life but could be paroled after either 7 or 14 years. But if I tell her, come over here, let me adjust your strap, and I'm found guilty of, what was it, enticing, sexual assault
In custody.
Against a person in custody.
in custody, then I'm sentenced to a minimum of 25 years with no possibility of parole or probation.
Well,
Is that correct?
no, sir.
Okay.
Because in the bill, we raised the 14 years on possibility of parole to 20 to make it mirror.
For murder?
Yes, sir, that's in the bill.
All right, that's what
It's
I was-
one of the changes in the bill. It's a
So I
small one, but
So I could get out after 20, but if I just touched
you'd be eligible for parole
and could get out?
if you were granted parole.
Yes, sir, after 20, but if the offender touched the breast, and that's it?
Well, if he touched the breast with the purpose of obtaining sexual gratification.
Sure.
This is not a law, because, and that's not a change in the law, that has been the law.
Yes, sir.
As I said, the only thing we're doing is creating a category of offenses against children that has a super sentence. And the answer to your question is yes.
So
If they're convicted of that crime, which is not just touching the breast, it is touching the breast of someone that the public has charged you with custody of, and that you've done it for the purpose of sexual gratification.
And it's more than your first offense, and those other circumstances don't exist.
Well, that's right. If you met the criteria for probation under new section 10-11-6.2, you could be probated for that.
Yes, sir, but that's,
If you have a prior sexual criminal record, yes, sir, you're going to serve 25 years under this bill.
But I would suspect, Ms. Bordeaux, that if you had a prior criminal sexual record, you would not be a teacher.
one would hope,
We'd certainly hope not.
certainly. Yes. I just,
Right.
we're all trying very hard to fit this into the big picture, and it just seems to me a little out of kilter if they're getting more prison time for sexual assault while in custody than you are for murder.
And Mr. Bordeaux, what I would say to that is, which I said, I believe, in the very first hearing to this committee now several months ago, the intent of this legislation is to try to protect our children who are becoming increasingly subject to unwanted sexual acts and violence against them. To send a message, as we did, I believe when you, and if I'm wrong on this, correct me, I think you were chairing Judiciary when we did the domestic violence bill came through. Were you chairing Judiciary?
It's been so long ago, I don't remember
Yeah.
either.
But basically, this body made a statement that we're not going to tolerate domestic violence. We really did. And our, people went out and said, well, how about this, how about this, how about that? But we said it's important as a policy statement to send a message. And I think the intent of this bill is to send a message to those who might have people under the age of 14 in custody. Be very careful what you do. And I'm just going to be very blunt here. If I were that individual, given the example, I would not adjust the bra strap of a young lady that was 12 years old or 11 years old or 10 years or, candidly, 15 or 16 years old. I think you're putting yourself in a situation, criminal or otherwise, that you don't want to be in. And I think unfortunately, the day we live in our society, I think it calls all of us who have supervisory abilities over children to really guard our actions and to be very, very careful of what we do.
There are no further questions this time by members of the committee. Do you want to continue your discussion, Mr. Leader?
All right. We were on 440. Oh, and there are no more questions to that amendment? Is that
Correct.
Okay. Well, as best I can tell, Mr. Chairman, when last we met, as best I can remember would be, we were at Section 5 on page 6. if any member of the committee.
That's correct.
Okay, all right. So what I thought I would do was go back sort of as an overview, keeping the chairman's instructions to me at the beginning in mind, and I'll move as quickly as you'll
Please do.
allow me. And then any questions? Section 5, page 6 really is the rape, I believe what we were just talking about. Is that correct, counsel? Of raising that if the victim, we're raising the minimum mandatory sentence to 25 years for rape regardless of the age of the victim. Currently that sentence is 10 to 20. Section 6, pages 6 and 7 have to do with sodomy and aggravated sodomy. And I believe I referred to these in my opening remarks last committee hearing about us, and I'm going to be careful how I say it, extending the Romeo and Juliet provision to sodomy, which currently is not in the code. And that, I believe that's the, down on, is that this one on page 7, lines 15 to 18?
Yeah.
Okay. That would be on page 7, lines 15 to 18. When the victim is 14 or 15 years of age and the offender is no more than 3 years older than the victim, then the offender is guilty of a misdemeanor and will not be subject to the punishment provisions. That is commonly called, I believe, the Romeo and Juliet clause that's currently in law on statutory rape, but is now added to sodomy. Also in Section 6, it really talks about, restores the age ceiling for aggravation to 10 years. And these are some changes from the previous bill against a victim under the age of 14. It raises the sentencing provisions for aggravated sodomy to 25 to 50 years in prison and subjects the offender to the sentencing provisions of this new code, Section 17-10-6.1. Section 7, page 7, statutory rape. If the offender is 21 years old or older, he or she will be subject to the mandatory split sentence provisions. If the offender is 21 years old or older, and there are no other changes to the statutory rape statute, we're not changing anything else in code. Section 8, pages 8 and 9 is the child molestation and aggravated child molestation code. I believe, Mr. Chairman, we have sort of talked about this indirectly through the discussion of these others. But it basically removes the age as an aggravating factor, and it creates a misdemeanor offense if the victim is 14 or 15 and the offender is no more than 3 years older, and only the aggravating factor is sodomy, the offender will not be subject to the sentencing provisions. Again, echoing what we said. It also deletes chemical castration and physician immunity and removes probation provisions from the current code for those offenses outlined there in Section 8.
Why do we?
Chairman Bordeaux.
Why do you want to remove that?
I couldn't hear it, Mr. Chairman.
Why do you want to remove the chemical castration?
Just for that, for child molestation or aggravated child molestation. You want to speak to that in terms of the minimum mandates and what we.
The reason underlying that was that it's discretionary with the court and with the defendant, but we thought that the minimum sentencing was a better way to go, and that there is treatment in prison, and this mandates talks about what happens if you're probated and things like that. It just seemed inappropriate in the context of changing the code.
Remember, Mr. Bordeaux, if they're convicted of this, they're going to spend at least 25 years in prison, and subject to the review of the Sexual Offender Registry Board, Review Board, they're going to be on the registry for the remainder of their life that they reside in Georgia, and be electronically monitored. And we felt like that was a.
Two other reasons. It did not seem, based on the research we did, chemical castration, A, does not seem to be completely effective, and B, hormones to get around chemical castration are available on the black market. So it seemed like a good idea when it was first put in the law. It didn't seem like something that needed to stay in the law.
Representative Tim Beard.
Disregard the question, Mr. Chairman. Thank you.
Thank you very much. Mr. Leader.
Continue. Section 9, page 9, enticing a child for indecent purposes. Again, I think this is reviewing what we've talked about, raises the sentencing provisions for enticing to 10 to 30 years in prison and subjects the offender to the mandatory minimum sentencing provisions. And it removes probation provisions. Section 10, which are pages 10 to 12, sexual assault against persons in custody. Again, going back to, I think, the amendment we just went through, it talks about with a person in custody there. Section 11, page 12, this is for incest. These are by...
Mr. Leader, if I could stop you there, recognize Vice Chairman Mumford.
If I could back up to Section 9, and I got to admit, I'm still looking at 2100 because that's what I had my notes on, but it's the part dealing with enticing a child.
You're looking at LC?
2100, but it's still Section 9. It's the part about enticing a child for an indecent purpose.
Okay.
All right. It's my understanding that the current law, this is a crime of 1 to 20 years at the discretion of the court.
Yeah.
Is that correct? I see Mr. McDade nodding.
I believe so. I wanted to look to make sure.
What we're doing here is changing that to a minimum of 25 to 50 years with no parole.
If. No. Continuing.
No, you're on the wrong page.
Page 9?
No, page 10.
Page 10.
10 to 30 years.
10 to 30.
And it would be subject to 6.2, which would also be subject to the amendment dealing with the parole. So if it was a first offense, did not involve any of the exacerbating qualities, then there would be a probation possibility.
Probation would be available.
Yes, sir.
On the 10 to 30 year sentence for enticing.
Yes, sir.
Okay. And obviously there's no age limit because it has to be a child under 14 to be enticing. Is that correct?
Under 16 is current law, and we haven't changed that. Yes, sir.
I guess the one I'm looking at says 14. I don't know.
I think you've got an old copy.
Old one.
Yep. Yes, sir.
Okay.
Yes, sir.
So it was changed to 14. Now it's back to 16.
Yes, sir. Yes, sir.
Page 10 of LC 292137S, line 6. Any person commits the offense of enticing a child for indecent purposes when he or she solicits, entices, or takes any child under the age of 16 years.
All right.
Mr. Leader.
All right. Where was I?
Section 11.
Where was I?
Section 11.
Section 11. Okay. Page.
Chairman Bordeaux.
I'm sorry, I'm not understanding. How do you reconcile Section 9, the element of enticing a child for indecent purposes, with the idea that you can get probation if there can't be any asportation in order to get probation? Because, and again, I readily yield to your your statutory expertise on this, but page 10, line 6, one of the elements is that you solicit, entice, or take the child to any place whatsoever. There's a movement there implied, it seems to me anyway.
You're right.
And so it couldn't be probated.
No, that's correct.
So when it's listed in the amendment, amendment page 1, line 14, it wouldn't be subject. That crime wouldn't be subject to probation. This is complicated. I mean, we've got all these, we all didn't do it in the existing law. We've got all these little provisions and ticks that have to be checked off on them. And it makes it more complicated. It seems like we want to simplify the law rather than make it even more complicated.
If there's under the amendment, if there's an asportation of the child, there would be no probation.
So if one is convicted of enticing a child for decent purposes, that person would go to prison for a minimum of 10 years.
And there was asportation.
Yeah.
And there was asportation.
Well, which is an element of the crime, so
Right.
they wouldn't be convicted of it, but for an asportation.
For the purpose of child molestation or indecent acts.
Thank you. Child molestation, too?
For the purpose of child molestation or indecent acts.
Oh, I'm sorry.
I think enticing is a bit of a sort of an attempted crime, luring someone for the purpose of.
Representative Mumford and then Representative Setzler.
I was trying to think of some fact patterns involving enticement. I remember a case in Rockdale County where we had a fella that, I don't really know that he had a sexual plan, and that he opened a car door was what the evidence was, and went to trial on that as enticing a child for indecent purposes. Child was in the front yard. He pulled up, opened the car door, maybe told the child to get in. I think there was a dispute about that. I was going to ask Mr. McDade if it's all right with the leader.
Yes, sir.
Can you maybe update me on some, I know y'all are a hotbed out there in Douglas County of all kinds of offenses. Maybe give me an example of enticing a child. Another example.
I'm not sure what he meant by that question.
Representative Mumford, a good example would be if an adult sees a child, say, at a shopping mall, and engages that child in conversation, tries to lure that child out into the parking lot to take the child to some other location, perform sexual acts, as the code describes. It doesn't require that you actually move the child ultimately. It's that you participate in soliciting that child to go to another place. So even under enticing, there might be an exception that would allow probation to answer some of the other questions, because you can't commit this crime without actually moving the child. You can commit it by soliciting that child to go to the location.
You're saying you can commit it without moving the child?
Yes. The act of soliciting the child to go to another place, calling the child on the phone, inviting the child on the internet to come to a location, asking the child.
Would you like some candy?
Yes.
And this is going to carry how much?
10 to 30. With the possibility of probation if it didn't involve that act of application.
Representative Setzler.
Mr. Chairman. Mr. Leader, I would offer as at least consideration as a friendly amendment. When you look at the crime of child molestation, there is the Romeo and Juliet provision where if they're within a three-year range and the victim is a certain age, that it's treated as a misdemeanor. Enticing a child for indecent purposes is defined as, and it goes through and it says, child under the age of 16 years to any place whatsoever for the purpose of child molestation or indecent acts. We're extending, if the act of child molestation is consummated, a Romeo and Juliet provision if there's a mutual agreement and so forth between the two actors. But for the purpose, but in the case of enticing, there's no such provision. I'm simply suggesting that maybe for consistency, the enticing charge would have that same clause that would allow two actors within a certain age range to be considered a misdemeanor rather than a felony.
Well, if they're under 18, it'd be handled as a juvenile case.
I'm looking at the case of, say, an 18-year-old and a 15-and-a-half-year-old. Again, I'm not looking to henpeck little examples, but I think there are some borderline cases here that might, for consistency, be more consistent if we had that clause in enticing as well.
Well, one of the elements of the crime is soliciting or enticing or taking a child any place for the purpose of child molestation or indecent acts. I think that would preclude consensual relations.
I don't know. I'm not sure that it always does. I think if you've got an 18-year-old actor and a minor, is an indecent act. Maybe I would defer to more astute legal minds, but I think.
Well, we count on prosecutorial discretion in a lot of these cases, and I think that if an 18-year-old is dating a 16-year-old, I can't imagine why there would be an indictment for this unless something more than going out took place.
But again, the enticing is contingent upon the expectation of child molestation. If child molestation has a misdemeanor provision for, folks within a certain age range, perhaps the presumably lesser act of enticing would also carry that. I just offer that as a friendly consideration.
Let's go. Mr. Leader.
And again, Mr. Chairman, just to conclude, for purposes of consistency, there's maybe some things we could find in here to shore this up and make it what I think intended to be.
Thank you. Mr. Leader.
We're at 11.
Where are we? Section 11, page 12. Incest, that's correct. We were talking about incest. It raises the sentencing provisions for incest to 10 to 30 years in prison. It creates a new provision that if the victim is under 14 years of age, the offender will be punished with 20 to 50 years in prison. We're talking about incest again, and subjects the offender to the mandatory minimum split sentencing. Section 12, pages 12 through 13, deals with sexual battery. Only change to the original on that, it provides that any second or subsequent conviction will be subject to the mandatory split. Section 13, page 13, aggravated sexual battery, again, raises the sentencing provisions for aggravated sexual battery to 25 to 50 years and removes age as an aggravating factor. Section 14, and this is pages 13 and 4. This is the aiding and abetting a sexual offender. And this is a new code section, a new crime. And this is in response, of course, to the Jessica Lunsford case. It defines law enforcement unit to include any agency charged with enforcing the laws and includes the Department of Corrections and the State Board of Pardons and Paroles. The crime of aiding and abetting a, a sexual offender includes providing false information about a sexual offender or harboring or concealing a sexual offender. The punishment will be as a felony with 5 to 20 years in prison. This provision does not require registration on the sexual registry list. And again, this is in response because of the family who concealed Mr. Cooey, Jessica Lunsford's killer. Section 15, page 14, the changes here, it makes probating a sentence subject to the provisions of the new code section, which is the one we've referred to numerous times, 1710, 6.2. And what this does ensure is that when a judge is fixing a sentence for a sexual offender, the judge uses the mandatory split sentencing provisions. Section 16, pages 14 through 16, is punishment for serious violent offenders. It reorganizes the section to provide that the crimes of kidnapping involving a victim 14 years or older or armed robbery will receive a mandatory minimum sentence of 10 years. Currently, all serious violent felonies, with the exception of murder, receive a minimum mandatory of 10 years. It changes the sentencing provisions for kidnapping under the age of 14, rape, aggravated child molestation, aggravated sodomy, and aggravated sexual battery to provide that they receive mandatory split sentences with a minimum of 25 years imprisonment. This is so the worst offenders, who we assume will be found to be predators by the reward, can be GPS monitored for the rest of their life in Georgia. This does not apply to misdemeanor child molestation or sodomy. Section 17, pages 16 to 7.
That's the amendment we offered.
That's the amendment we offered, so we've got that. Section 18, page 18.
Could I ask a question?
Vice Chairman Mumford.
On, I'm looking at page 15 on 2137S, aggravated child molestation. It's line 18C. Isn't an act of sodomy one of the underlying acts that can lead to an aggravated child molestation?
Yes, it is, except in our bill we have a Romeo and Juliet provision that excludes actors who are 14 to 17 and 15 to 18. If the only aggravating offense is sodomy, then it's a misdemeanor. That's the new exception that we created.
So you can't be charged with aggravated child molestation in that range and not be subject?
You can be charged with it, but it'll be treated as a misdemeanor if the only aggravating circumstance is sodomy. In other words, if you have a 15-year-old and an 18-year-old, and the 18-year-old is charged with aggravated child molestation because they were committing sodomy, that's an exception to the minimum mandatory of 25 years.
And it carries misdemeanor?
Yes, sir. That's a carryover from the statutory rape and regular sodomy.
So, essentially, the only things that are not eligible for misdemeanor treatment between between juveniles, I guess we should say, are murder, kidnapping, and rape.
Yes, sir.
Everything else is subject to being treated as a misdemeanor. That would be aggravated child molestation, aggravated sodomy, aggravated sexual battery. Is that correct?
Not aggravated sexual battery, because that would involve an object and injury.
Okay.
And that would also, that's one of the 7 deadlies under the Juvenile Code, so they're going to be treated in the Superior Court system anyway. But because we didn't change the definition of aggravated.
Correct.
Yeah, we kept the law the same. It seemed appropriate to remove, if we were making a Romeo and Juliet exception for sodomy, it seemed consistent and logical to carry it over into the if that was the only aggravating circumstance for child molestation.
I hate to belabor this. Refresh my memory. What are the other circumstances for aggravated child molestation?
I believe it's physical injury to the child.
So it's either sodomy or physical injury to the child?
Yes, sir. And we're excluding sodomy if it's between teenagers.
Mr. Leader.
I believe the last change that this LC had over the ones that we previously heard goes to Section 17, which is pages 16 to 17, and this is the code section that deals exclusively with the punishment for sex crimes, not covered under 1710-6.1.
That's your amendment.
And that's the amendment, again, that we put in there. Right. Those are the only changes, Mr. Chairman, that this particular LC version that we're working off of is from the original bill that we started with, I think, some 6 hearings ago. If I may, Mr. Chairman.
Yes, sir.
There is one change, and that's Section 19.
Oh, here. That is correct.
Section 19 is collection of information.
Yeah, I'm corrected by counsel. Section 19, pages 18 to 19, collection of information. This adds age and sex of victim to the definition of term criminal history record information to ensure that crime information and statistics include information about the victim. Today, I know we're joined in the committee room by members of the Boyd family, Miss Kimberly Boyd, who unfortunately late last year, as most of us know, in Cobb County, was the victim of a carjacking. She was subsequently killed by the offender, and except for the heroic efforts of an innocent bystander who watched what happened, we don't know what would have happened after that. Unfortunately, the offender was currently on our sexual registry list, but not in prison. It's too late, obviously, to do anything for Mike and his family, but it's exactly those type of situations that we're trying to prevent from happening again. And Mr. Chairman, we've worked extremely hard and have been open to suggestions, and I can't count the number of changes, and we still are. But it's our intent to get this bill out, get it to the floor, get it debated to the Senate, or over to the Senate for the next round of hearings, which, as you know, will start all over again and go through over there. And we certainly, I personally appreciate so many members of the committee who've come by to see me and have talked to me personally and made suggestions, many of which are incorporated in this latest version. The amendments that we talked about, I think Representative Franklin has told me he has an amendment, which certainly sounds good. I think Representative Knox mentioned an amendment, or now two, I guess. Is that right, with the changing of the wording in C? Amendment to the amendment? Yes. That those are perfectly acceptable. I'm not aware of any other amendments, but certainly there may be. But with that, Mr. Chairman, I will conclude my remarks and be available to answer questions.
I'm going to recognize a member of the committee who had a question, but before I do, I just want to say to you, Mr. Leader, that I just appreciate so much the tremendous amount of work and leadership that you have shown on this issue, the commitment you've had to improving our law, I think is certainly very, very commendable. I know Mr. Choate has done outstanding work at your side, and Sally Fox and House Research, Jill Travis has been a real trooper, drafting all of the various versions and the amendments, and so a lot of people played a tremendous role in this entire process. Chairman Knox.
Thank you, Mr. Chairman. On page 19, I'm told by my friends at GBI that line 2 and 3, or portions of 3 anyhow, where it says such term also includes age and sex of each victim that's provided by criminal justice agency, would be better just from a mechanical standpoint if it were included in the section on the sex offender registry. The criminal history is restricted to someone by other portions of the law not included in what we've done here. And so to some extent it causes a problem as far as the fields, the information fields that are in the different, that are different in the criminal history and different in the sex offender registry. So all I'm suggesting is that we move that sentence over to the sexual offender registry portion of the bill, and that would come in about on page 29, line 33 in this particular version that we have here. And I think, I'm not sure exactly how it would be inserted there, but that would bring it in under the sexual offender registry rather than under the criminal history as it currently is written. I don't think it would change it, except that there's something, I'm told there's a considerable amount of expense in changing the field, the information field on the criminal history, because it doesn't include this information now, while the sex offender registry does include the information in there. That doesn't require changing the data fields. That's the only reason if the author would have entertained that motion, I'd offer that as well.
Just want to make sure I understand. You're talking about deleting the sentence, not in addition to on page 29, line 33. Moving. Okay.
Moving it over to what amounts to the sexual offender registry according to this bill, and that would, I think, be, I'm told, is at page 29, line 33 is the place where it could most easily be inserted and affect the savings and the mechanics of it.
Representative Knox, I think where they're talking about putting it would make that disclosed to the public, and the place that we put it in the code, and maybe I can let Ms. Travis address that issue, but this is information that is normally collected and sent to the GBI by every time an offense is someone is convicted. The problem, one of the issues we had in this case was trying to find accurate information on age and sex, because it's not kept by anybody at this point. And moving forward, we felt that if we needed to, if any future General Assemblies decided they wanted to look at this issue, that they would have better information than we did. And we put it in the place where the superior courts and the law enforcement agencies report to the GBI. So,
I'm not an expert on this subject. I'm just telling this has been a suggestion made by us. So you guys keep this information. And one of the things about it is that it can be available on the sex offender registry without having to change data fields and the forms that they use and all that sort of thing. And your language, the further language on page line 35 restricts the use of that information except with respect to authorized data gathering activities. So it's not available to the public, but it would be available for use without having to change the current data formats that they use to use the criminal history rather than sex offender registry.
Chairman Knox, are you?
Too technical to do at this point. But
Yeah. What I would say, Mr. Chairman, in response to that is, I don't know how to respond because I just heard it. You see what I'm saying? And we'd have to look at that. Yeah, right. And while we certainly, the author, my intention is to cooperate fully with the GBI and want to help with them, I believe that may take a little more research and may be one of those items that Senator Smith and Chairman over in the Senate could look at as we move this bill forward.
Questions by the committee? Vice Chairman Mumford.
I would like to turn to the, and again, I'm looking at 2100. It's the section relative to the sheriff. It's on page 26 of 2100.
I don't have 2100. So.
I know. I got it. It'd be on page 27 of the new bill. I think it starts at H. The sheriff's office in each county shall prepare and maintain a list of sexual offenders. Are they currently doing that? Is that correct?
Let me see. I'm finding them. Go ahead.
H1.
Okay.
Yes.
All right, that's current law, right?
Yes, it may not be written exactly like that. We've reorganized it so that we've put responsibilities for each person in the system in one place as opposed to having it referenced to many, many different places. It's a reorganization. But.
And it says that the sheriff is going, you say it may be different from the current law. Under Section 2, is there a current requirement for 2 working days? That it has to be reported within 2 working days?
No, that's new.
Would you all be amenable to a friendly amendment to give the sheriff a little more than 2 days to do that?
If the sheriffs do it now, in meeting with my own sheriff and some others, we've talked about this. But if that, I know I've got them to my back, and I'm going to keep my eye on them back here. But
that's my sheriff sitting behind you.
Well, you do have your hands full then.
That excuse me, that particular thing has not been an issue so far.
All right. Maintain and post a list of every sexual offender residing in the county, and it says in the sheriff's office, which I understand.
That's correct.
And then it says B, in any county administrative building.
All right.
Now, we got a bunch of administrative buildings for road work and animal pound, things like that. Do we mean any administrative building, and what's the definition of administrative?
Go ahead.
I think the intent of this was to give the sheriff the requirement to post it in administrative buildings, but to use some discretion about other buildings where he thought it was necessary. It does not mean all administrative buildings.
Well, then y'all would agree that we might need to make a little change there to kind of show that that's directive rather than mandatory.
That certainly was not the intention there.
I'm concerned too. You know, my sheriff and my city police chief, sometimes they don't get along, and the next one says he's got to go over to the municipality and post it. They probably want to post their own. Office of the clerk, I don't have a problem with. Website, I don't have a problem with, except there may be places where we don't have a website.
Well,
I'm concerned about how we're going to pay for that.
Well, Mr. Mumford, let me address that. I think it's time that they do have a website. The access to this information, which is critical to our citizens, I know the ones in my county are obviously through these past few months very aware. But if there's a sheriff's office in the state that doesn't have a website, I think it's time they moved on into the 80s with us, and that's not a large expense. But I will tell you this, Representative Mumford, the commitment from the Speaker of the House from the very beginning of this is we are not going, if local sheriffs demonstrate for whatever reason, then they can come through their delegation for any funding they may or may not need. But I know I maintain a website just for campaign purposes, and it is not a very expensive proposition.
Well, there is a cost there, and what you're saying is that you expect that cost will be borne by the state?
No, that's not what I said. I said if there's a county that cannot afford, under your scenario, to start a website in their county for registered sex offenders for their citizens. So the citizens in their county wouldn't have the ability to know who they are or who's living in their county. I believe that that's not an undue burden on any sheriff's office, but I'm certainly more than willing to listen to a story.
I thought somewhere in this section that it said that he was to post it in any public building. Has that been taken out or something? I don't see it right now. Main administrative building. I'll move on.
Okay.
Right, line 34. The sheriff's office may, this is not shall, may post a list of sexual offenders in any public building in addition to those locations enumerated in subsection H.
What section are you in, Representative Mumford?
I'm sorry, I'm on...
I think you're on the wrong LC.
I stay on it, because that's where my notes are. Let me go back and show you where I am.
I think it's on page 28, line 22 of LC 29, 21, 37.
It was I-1-2.
Yes.
The sheriff's office may post a list of sexual offenders in any public building in addition to those locations enumerated. What does that mean?
Let me give you a very good example of that in a county that I used to represent a portion of prior to the judges removing those maps. Bryan County has Fort Stewart that runs right through the middle of it, cuts the county directly in half. Just about everything they do in that county they have to duplicate, because even 911 and that type of stuff. What we wanted to do is give the sheriffs the ability, that's why it says may and not shall, that if in their own local jurisdiction they feel like that access to this information might be more accessible. For example, in my own county, the sheriff, instead of over in Brunswick at the courthouse, he may want to post at the county annex building on the islands for particular senior citizens. A lot of them live on the islands. If the sheriff so desires to post that information there, we want to give them the ability to do that. The intent here is to make this information as readily available. A sexually registered list is really of no value to anybody unless the citizens can have access to it. And that's all the intent is here. It's not to really mandate the sheriffs do it, but they know their counties and far better than we do, and if they feel like the geographic structure of their county would lend to putting in another building, we certainly wanted them to have the ability.
So you don't anticipate putting it in buildings that are open to the public. You're talking about government buildings.
I thought government buildings are open to the public.
They are. I'm wondering if I just wanted to know if this provision meant that it would be posted in any public building open to the public.
Help me understand.
Can it be posted in a restaurant, for instance, or a grocery store?
I think the intent was not to limit it to any place where there's public access. If the sheriff feels that it's appropriate to put some list there, that yes, he can in fact do it.
Drawing a distinction between public and government.
Yeah, Representative, I can't imagine, and your sheriff is behind me, probably he can answer that, the sheriff would want to put it in the Winn-Dixie or the dry cleaners. But again, I'll respond to that as a citizen. If the sheriff in my county, for whatever reason, felt that the dissemination of that information needed to be done there, I think most sheriffs who are elected would use great discretion in doing that for their citizens. I have full confidence in our sheriffs to make those kind of value judgments. Again, the intent's not to do that. The intent is to help those counties, particularly like Bryan and others that have unique sort of geographic situations. Rather than putting it in one location and you have a senior citizen that doesn't have access to the internet, unless someone does it for them, they don't have the ability to get that list.
On line 14, right above there, the sheriff is charged with collecting the annual fee, which it's my understanding the registrant has to provide on his birthday. Mm-hmm. Every time he has a birthday, he has to go down to register and pay the $250 fee, re-register, and pay the fee for the year. And it says that the sheriff is responsible to transmit that fee to the state for deposit into the general fund. I'm wondering if maybe that fee had better be left to the sheriff's department so that they can fund with that fee the expenses that they're going to incur in complying with this section.
Now, sir, the intent of this, Representative Mumford, is there is going to be some expense involved at the state level to do this. And to get these, of course, at this point in time, we're talking about people that have already been convicted, gone through the system, served their time, and now they're out on the registry list and being monitored. That $250 was to help us at the state level offset those expenses and bring some revenue into that. Now, what again I think I'd be willing to look at as we move this forward is if, like we do in some of the other answers where they would keep X percent, $5 or $10 a time or whatever, then we'd look at that.
Okay. Chairman Knox.
Chairman, are you going to entertain some amendments?
I am. Very shortly. Okay. Chairman Bordeaux.
Thank you, sir. I'd gotten a letter from my local sheriff and the assistant DA who prosecutes child victim crimes who have serious concerns about some portions of this bill. And let me try to address my questions to some of their concerns. On page 27, the line dealing, I guess starting at line 29, does that mean that, as I read that, that means anytime there's an update to this list, which would be anytime there's a change of address, there's a new person at it, there's a person taken off, there's any of these many changes involved here, the sheriff has to deliver the new list or the change in the list to every school in the jurisdiction. In Savannah, that's, according to the sheriff, 86 schools. Is that what?
Can't that be done electronically?
Is that the current law?
It was written in such a way that posting on the sheriff's website, to which all institutions would have access, would qualify for that.
Well, you may be exactly right about that, but on page, as I read it, page 27, line 33, it says, such list and any additions to such list shall be delivered immediately to all schools or institutions of higher education located in the county. That doesn't sound like posting it on a website to me. That says you take it to the school and you take it to the school immediately.
Couldn't it be electronically transmitted? I do list. I do a lot of things electronically these days, including, I believe, Legislative Council transmitted a bill to me electronically.
It may be. The Court of Appeals, of course, has said that a fax is just a series of blips and things like that.
That's another issue, but I believe if the sheriff's office updated their website and that list was transmitted, that would meet those requirements.
I think that if you put all those email addresses into your computer, you can actually send those updates by just pressing one button.
That may be, and that certainly would be the sane way to do it.
Mm-hmm. Right.
that's not how I read this. Certainly, if it says shall be delivered immediately, that means to me that I deliver it to you, not transmit it to you. Would you have any objection to specifying that it could be that delivery shall include electronic transmission?
Not at all, Mr. Porter.
Hopefully one last question. I think I've said that. Page 28, line 15, dealing with the $250 registration fee. Is there any initial registration fee, or is it only on the anniversary?
It's just only on the anniversary.
The sheriff in my county has indicated he's very concerned about the labor-intensive aspect of that. Do you have any response to that, other than it won't take that much time? And what happens if they don't pay it?
What happens if the offender doesn't pay the $250? They're in violation of the law.
And what happens to them then under this bill?
I would suspect your sheriff would arrest them.
And they've got to pay it within 48 hours of their birthday.
I'm having a hard time hearing you. I'm sorry.
I'm sorry. And they've got to pay it is that on? I can't tell.
Yeah.
They've got to pay that $250 within 48 hours of their birthday.
Correct.
And if they don't, what happens? They go to prison?
That's exactly right. Mr. Bordeaux, if a registered violent sex offender who has been electronically monitored in this state is going to be abundantly aware of their responsibility. This is an annual registration. It's not one that they have to go every week or every month. One time a year to file this fee. One of the things we don't want to do is lose track of these people, which has happened. You take a 10-day, a 14-day, or a 21-day, you lose track of them and where they are. The intent, again, is to monitor and keep hands-on on where these people are. And, I certainly couldn't speak for a sexual offender, but I believe if I'd spent 25 years in prison and continued to reside in the state and was being electronically monitored and knew that I'd be in violation of that if I didn't report, I think I could make sure once a year I was there within 48 hours. Perhaps you think that's unreasonable. I don't.
Well, the fear, of course, is if I say, oh, that's unreasonable, I'm soft on crime.
No, that's not at all the case. But remember, let's go back to the intent of what we're trying to do. Once we've identified an individual, now we're way past that. This is a person that has met the test by a jury of all the aggravating circumstances. They have been reviewed prior to their release from prison by the Sexual Offender Registry Board and deemed to be of such a nature that they present the possibility of future actions against our children. All right? As I say again, to pay a $250 fine once a year on their birthday within 48 hours, I personally don't think that's unreasonable. Maybe you think it should be 72. But, then where do you go? Is it 5 days, or is it... So then where are we?
Well, the whole premise of much of this bill I honestly do have problems with, and I don't want to get into all that now because of time constraints, but the premise is, gee, if we make the sentence incredibly tough, there's going to be some thoughtful, conscious decision that these crimes aren't going to be committed. I just don't think most criminals work that way.
I think not only, and you can respond to that, what we're trying to do is these are people that have already been convicted of committing these crimes who have a very high propensity to do them again. The only way I know, and you can never prevent them all, you and I know that, whether it's murder, whether it's armed robbery, or any other offense against the code, there's certainly nothing we can do at a legislative or a law enforcement basis to ever say we'll never have another crime. But I think it's incumbent upon us to make sure that we do everything reasonable to make sure this doesn't happen. And we know the people at the highest risk to commit these crimes again are those that have already been convicted under what we've brought out in this bill, that have served their time, and in addition to that, been deemed prior to their release after 25 years. When certainly during that 25 years, the rehabilitation aspects could be available to them should they choose. If they come back into the public sector at the end of that time and are deemed to have a high rate of the possibility of returning, I don't know what we can do that's too tough on these people. I think we owe it to our young children. And let me just go a step further, Mr. Bordell. I will say this. If they come out of prison, and you use the term, I think, a thoughtful something by the predator, if they feel like the laws in Georgia are too tough, perhaps they'd move to another state. Now, let me give you an example in your neighborhood, in Savannah, which one of your local TV reporters brought to me. Case of an individual who committed an aggravated sexual offense in the 80s, late 80s, went to prison under Georgia, got out after only a few years in prison, and moved to another state. That state has already enacted a very similar law that we're doing now. And you know what that individual did? They moved back to Savannah, and they're living within blocks of their original victim. I don't want these people moving back to Georgia. I just assume they leave Georgia.
Vice Chairman Mumford.
Yes. I wanted to, since my sheriffs come here, I have one of the finest sheriffs in the state of Georgia. I want to give Mr. Jeff Wiggy an opportunity to speak. I know you came here to speak. I'd like to hear what you came about.
Over here.
Yes, wherever you want.
Just briefly, on behalf of the Georgia sheriffs, we want you to know that we wholeheartedly support this. We just want to make sure that it's something that we can enforce. We have some concerns about some of the tracking that's involved. We also have some concerns about the amount of money that's collected. We agree that the state will have some expenses initially, but we're the ones that are going to have the expense year after year after year. So just go on record, we support your bill 100%. We wish you would allow us to offer some suggestions in things that might make it easier for reporting or whatever to us, and also that a possibility of these people remaining on parole or probation the rest of their life might, that way that the state would be the one monitoring where they're at different times and things like that, and that's who would be collecting the money. But we want to help you do anything we can to make this work.
Do you have a specific list of proposals as far as amendments? Or
we do, and the Georgia sheriffs have actually gotten together and appointed staff members to come up with ideas, and they've been working with pardons and parole, and they have a list of things that we think are just really going to be difficult for us and things that would help matters, and we would love to share it.
Can I respond? First of all, thank you, Sheriff, and thank you to the association for the support. I believe, and correct me if I'm wrong, that the language that we're talking about now has stayed fairly the same since the initial introduction of the bill on the first hearing, which was back in
September.
I've certainly not seen these suggestions to date, and it's January the 31st. I'm more than open, Sheriff, to work with you guys. And I understand, but here we are at the 11th and a half hour, and this would have been, information's a wonderful thing when it's timely. And it's my understanding that representatives of your association met with Counsel Choate and others at that time, and at that time have not showed us or given us any of those suggestions.
I would have to defer to our counsel right here.
Thank you. And you're absolutely correct. We did meet with Mr. Choate in his office, along with several others. We offered many suggestions at the time, some of which were in fact taken, some of which were not. And some of the ones that were not taken that we still have some concerns about.
Well, if I might, Representative Mumford, we have met with the representatives of the sheriff on a number of occasions, and the last time I met with their representative who works with the legislature, we did in fact accept most, if not all, of their suggestions, and I was told at that time, about 3 weeks ago, that the sheriffs had no problem with the bill at that point because we put in a number of changes at their request. Since that meeting, no one has contacted me and said that there were any other suggestions that they wanted in, and it was reported to us that the bill was fine. So,
and I would say, as the author of the bill, I want to reiterate that absolutely I want to work with the sheriffs. These are the guys we're depending on to keep these people in jail, and we'll support you in any and every way. What I would like to suggest is that we still have a long way to go on this bill in terms of, we'll have a time between hopefully today and when it comes to the floor. I'll be glad to meet with you or your representatives and Mr. Choden. If there are amendments, there's always the ability on the floor to amend that bill. If not, if we're still not comfortable, then as it moves through the Senate, I'll work with you. But you have my public absolute, I will publicly state to you, I will work with you and your organization in every way to make sure that this doesn't place any unreasonable or undue burden. And if there are, as we begin to go through this process, if costs begin to rise that we cannot add up today, we just don't know, something happens, then I know the leadership of both the House and the Senate are prepared to meet that.
Sheriff Wigginton, let me just say that I appreciate you being here, and I will work with the majority leader to be sure that any suggestions that have not been considered will be as we go through the process, because we do appreciate you, and I appreciate your being here.
Thank you.
Absolutely.
One quick comment. We want to help make this work. One of the comments earlier about different agencies being able to do things, you have to understand that out of the 159 counties, most of us are lucky enough to have quite a bit of staff. There are sheriffs that have one or two deputies that still work for them. And we just want to make sure that what you legislate will actually be enforceable statewide and realistic statewide.
Right.
Thank you.
Okay. Representative Setzler.
Chairman. Representative Keene, Mr. Leader, I do have one thing I'd like to put before the committee, possibly consider as an amendment. I have talked to you briefly about this in the past, and your counsel, is the issue of age separation for kids in their teen years engaged in, understand the age of consensual sex in Georgia 16, but what we'll call, if you'll indulge me to call it consensual sex for purposes of the discussion, sex between 18-year-olds, 15-year-olds, 17-year-olds, 14-year-olds in the context of a consensual environment. I have, as you may know, been committed to mentoring youth for much of my adult life. Worked in a number of contexts from my college years through now, and I consider working with young people one of the real delights of my life. Contrary to the best efforts of many great leaders in the church, in the schools, and a number of organizations across our culture, recent statistics show that 70% of 19-year-olds surveyed, 70% of 19-year-olds indicate they've been involved in sex at some point in their past. 17% of 19-year-olds report to not be virgins. That troubles me. Troubles me deeply.
May I ask you something there? 70% have been involved in sex with children under the age of 14?
No, Mr. Leader. I'm just 70% of 19-year-olds indicate they've been involved in sex in some context by an interview of 19-year-olds at some point during the 1990s.
I misunderstood. Okay.
Could be 19 and 19, 19 and 18, 19 and 17,
okay.
Somewhere.
I'm with you.
You had laid out for us, and I think very articulately, and I think we embrace the value of this bill, that as we cast a broad net to catch sex offenders who we think now are, and in fact we have tragic cases that are slipping through the system, we don't want there to be any unintended consequences. And I'm 100% with you, and we'll fight and do what it takes to make sure that happens. An unintended consequence I'm concerned may happen with this, that I believe is happening currently under existing law, is the concern of the 3-year separation as designated in the relevant code sections. Your counsel mentioned, and I've spoke with him in detail, and I appreciate his personal time that he spent after hours many nights of the last several weeks talking about this and some other issues. The Romeo and Juliet clause was intended to address, not decriminalize, but address the issue of sex between 15-year-olds and 18-year-olds 14-year-olds and 17-year-olds, to recognize that as a misdemeanor, not as a felony, but recognizing the impact that felony charges have on young people for the rest of their lives. I think in line with that spirit, and again, I wasn't one of the drafters of the existing law, the idea of 3-year separation, being 15-year-old 9th graders and 18-year-old 12th graders, or any combination thereof. The intent is that 3-year separation, no one would look to decriminalize and say is okay and underwrite, but that's kind of an age range where we're looking to not have the felony provisions of sexual registry for life and the 1 year, 1 to 20 year sentence play out. My concern is, specifically in that context, when you look at the age ranges of kids that are, quote, 3 years apart, the way the law is drafted and is in current code, if you have an 18-year-old with a February birthday and a 15-year-old with a May birthday, it's not a technicality, but it's very real law that that's more than a 3-year separation in age, and a, quote, consensual sex act between that 15-year-old and that 18-year-old would trigger the felony provisions of existing law. If it were an act of sodomy, would trigger the aggravated child molestation provisions of this, which, as I read the law, the new law would require a 25 to 50-year sentence and registry for life for the 18-year-old. What I would offer to you, and again, Ms. Munns has been very articulate and strident and kind of sharing her concerns about this, I think in the spirit of the 3-year age range, and I think we're not looking to throw any bounds off or broaden provisions of how the current law is written, but I think in the spirit of that 3-year age differential, if we extend the felony charge range from 3.0 years, as it's in effect practiced now, to what would be 4.0 years, those kids with 3 years age separation, that might be 3 years 2 months, 3 years 6 months, wouldn't get caught up in the execution of how this plays out, and that 3 year 6 months age separation wouldn't be a felony, but would be treated as a misdemeanor as outlined in the current code.
Well, Representative Setzler, I appreciate that. As you know, the 3 year has been in current code and continues to be in current code. We extended that Romeo and Juliet, I guess is the clause that's used in the legal circles, to sodomy, to include that, which is currently not in code, so we're taking a giant step forward. When you get into ages, and what you're talking about doing is actually reducing, if you will, current code. Then perhaps we get into the, whatever birthday or age you pick, there's going to be somebody after that as well.
Sure.
And, currently it's 14. Do we say, well, let's make that 13, or do, you get to it. When we began drafting this bill, we tried to stay with current code as much as possible. Candidly, I'm very comfortable with that 3 years, and I think when you start getting outside of that, and I think this is what the prosecutors told you as well, you're raising the possibility of really allowing some people that I understand what you're trying to protect actually to escape the net that shouldn't. And I'm very comfortable with the 3 years, and I would ask that we hold that 3 year provision. At this point in time, I think it's reasonable. It's in the code. It's worked, and I would prefer it stay that way.
Chairman Franklin.
Mr. Chairman, at the proper time, I'd like to be recognized for offering an amendment.
You're recognized.
I would like to direct us to page 34, where we're dealing with if you're on probation.
Okay.
So at the very top of the page, you have the court may provide that the probationer shall be, 1, prohibited, then down to line 5, from entering or remaining present in areas where minors congregate, child care facilities, churches, or schools. And once these people have left jail and they're on probation,
I believe about the only place that they will have their life transformed is by entering and remaining present at a church service. And if you'll indulge me, Mr. Chairman, just want to read a few sentences here that the Apostle Paul wrote to a church in Corinth, where he said, "Or do you not know that the unrighteous shall not inherit the kingdom of God? Do not be deceived, neither fornicators, nor idolaters, nor adulterers, nor effeminate, nor homosexuals, nor thieves, nor the covetous, nor drunkards, nor revilers, nor swindlers shall inherit the kingdom of God. And such were some of you. But you were washed, but you were sanctified, but you were justified in the name of the Lord Jesus Christ and in the Spirit of our God." So in the spirit of, we want these people transformed after they've gotten out of jail. And so I would propose AM 290436, where we change the words "entering and remaining present" to "loitering," so that you may enter, you may attend the church service, but you just can't loiter, which is a technical term.
Chairman Franklin, you and I have discussed this. As you know, I'm more than willing to accept that amendment. I think your work is well done, and I concur.
Thank you.
Thank you, Chairman Franklin. Chairman Knox, you had indicated earlier that you had an amendment or two to offer.
Thank you, Mr. Chairman. I've previously spoken with the author with respect to on page 35, line 6 of LC 292137S.
Do we have that one?
Yes, sir. That's the version we're looking at. I do not have the amendment prepared.
Okay.
Sorry.
Okay. Jill?
I think I did, but I had to amend the amendment, so I don't have it. In any event, it would simply be striking line 6 in its entirety. Would be my comment.
Would you restate that?
Yes, sir. Page 35 of LC 292137S, page 35 at line 6, striking in its entirety at line 6, so that we're leaving out, I guess that's subparagraph 6, obscene telephone contact as defined in Code Section 1612-100.3. That will be struck in its entirety.
Mr. Chairman, would your amendment also on line 3 after the semicolon add the word "or," and then on line
Yes, sir.
5 after the numeral 2 strike the semicolon in the word "or" and put a period?
Yes, sir. Thank you.
Does everyone understand the amendment? Is there objection to the amendment?
No, sir.
Hearing none, that amendment will be adopted. Let me go back to the Franklin amendment. I know you indicated no problem. Was there objection to the Franklin amendment? Hearing none, that one will stand. It will be adopted. You're next. Did you have others, Chairman Knox, or was that all?
Well, there was the wording, I believe, Chairman Knox, about, help me with the term, relevant evidence.
Yeah, right, on the...
Just trying to help.
Issue thing.
I've got the language.
Bordeaux, can you help me?
Could Mr. Choate read what we've written and see if that's acceptable?
Sure.
I think what you had suggested, Chairman Knox, was that on page 2, line 7, it would read, "The court has determined that relevant similar transaction evidence has not been found."
What page?
This is on AM 290449, the amendment that we took up earlier. Page 2, line 7.
And if I might, that would read, with your amendment, would be, after that, insert relevant, delete does not exist, and insert after evidence has not been found, semicolon.
Yes, sir, that's correct.
All right, sir.
Questions about the amendment? Chairman Bordeaux.
May I make a suggestion about that language, and this is in the spirit of a friendly amendment? What about something like, "The court has not found evidence of a similar transaction"? Would that get to the same point and maybe a little bit more cleanly?
Mr. Bordeaux, candidly, I'm going to let you legal minds lawyer that.
In the opinion of the chair, it does.
I agree, Mr. Chairman.
Are you
The
offering
court,
amendment to?
Chairman Knox, would you take that as a friendly substitution to let line 7 read, "The court has not found evidence of a similar transaction," of a relevant similar transaction?
Of a relevant similar transaction, is that what you're saying?
Yes, sir.
Yeah, that's, I think it's.
Okay.
Would you withdraw your amendment?
I will.
Okay. So now we have the Bordeaux amendment to Amendment 0449. Is there-
Bordeaux-Knox amendment, or Knox-Bordeaux amendment,
Okay,
I think.
you're going to share credit.
We might want to mark this date down.
I like this. This happens a lot down here. Is there objection? Hearing none, that amendment to the amendment will be adopted. And at some point, I would remind the members of the committee we need to move on that amendment as well as the others. I think there was one or maybe one more.
Yes, sir.
Chairman Bordeaux, do you have another matter?
Yes, sir, on this same amendment to the amendment, something we talked about, and I think this would be acceptable language. Page 2 of AM 290449, line 10, delete the word asportation and insert in lieu thereof transportation.
That's correct.
Is there objection to that amendment to the amendment? Hearing none, that one will be adopted. Let me jump in. Vice Chairman Mumford, I think you sat too close to me. I missed you.
Is this, I have several amendments, but is the amendment, I know we're looking at the amendment here, is this to Section 7, page 7, Section 7? Is that where this amendment goes?
No.
Amendment 0449.
449?
Right. Where is it?
I believe it's Section 17 that begins on the bottom of page 16 of LC 292137S. That's where AM 290449 would go.
I think it's lines 33 through 35 of page 16. It strikes.
Yeah.
On page 16.
Oh, okay, I beg your pardon.
Okay.
Okay. Chair recognizes Vice Chairman Mumford.
I would like to offer an amendment in this same section. It would have to be B, C, D, E, F, G. A new G, which would read as follows. Whenever any person who has not been previously charged with a sexual offense and is charged with an offense enumerated under Section B or C of this code section and is under the age of 21, pleads guilty or is found guilty of the offense, the court may, without entering a judgment of guilt and with the consent of such person, defer further proceedings and place him or her on probation upon such reasonable terms and conditions as the court may require. Upon violation of a term or condition, the court may enter an adjudication of guilt and proceed accordingly. Upon fulfillment of the terms and conditions, the court shall discharge the person and dismiss the proceedings against him. Discharge and dismissal under this code section shall be without court adjudication of guilt and shall not be deemed a conviction for purposes of this code section or for purposes of disqualification or disabilities imposed by law upon conviction of a crime. Discharge and dismissal under this code section may occur only once with respect to any person. This would in effect add to the amendment that you already have, language which is essentially a first offender clause similar to other first offender clauses. And I'll make that motion.
Questions about the amendment? Does everyone understand that the amendment, as I understand, restores or allows first offender treatment in certain limited cases? Is that correct, Vice Chairman Mumford?
Well, it allows first offender treatments in most of the cases.
Representative Stuckey Benefield.
Thank you, Mr. Chairman. I just want to make sure I understand. This is first offender when the defendant pleads guilty, is that correct? Or the accused?
Similar to the way first offender is currently used, you're allowed to enter a plea under the first offender. Adjudication is withheld until you fulfill the terms of first offender treatment. And then a first offender exoneration is determined to be a predator.
Yeah.
This would only apply to persons under 21 years of age.
That's the question I was going to ask. Thank you. So we're only talking about persons under 21.
If they're over 21, first offender is not available.
Chairman Cooper.
Thank you, Mr. Chairman. Under that circumstances, is it saying that the court has the right to make the decision on the terms of that, and that they would, like one of those terms would be, they would not be put on the sexual
Absolutely.
offender register?
The court can require, first offenders can actually be under a first offender order for many, many years. 10 years, they can actually serve prison terms, they can be ordered for treatment. The whole panoply of whatever the criminal justice system can do to them is available under the first offender. And they would have to complete those things before the first offender
But, excuse me, but they wouldn't necessarily, the judge could put them on the sexual registry, but he wouldn't have to.
Correct.
Once the first offender, if they successfully complete first offender, they wouldn't have to be on the registry. The current law is if you are, while you're on first offender, you must be registered. Right. If you're in a qualifying crime.
First offender doesn't, even if you're on first offender, you still have to be on the sex offender registry until you complete all the requirements of the sentence, whether it's probation, prison, or whatever it is. You still have to be on it until you finish it.
You'll hold your thought. Legislative Counsel, did you want to clear this whole area up?
Well, I thought we did away with first offender under the registry last year. Am I wrong about that? Or is it still partially there? I'm looking. I know we did something about first offenders last year.
Mike
The
Boggs'
2005
bill.
amendment note. We deleted a paragraph. That's one issue I want to look at further. Number two issue is in this amendment, if you look at page 1, line 26, you have a restriction that nobody can get first offender. You're probably going to have to change something there too. And then Chairman Cooper's
Yeah, but doesn't
question
this
about
take care of that?
the tie-in to the sex offender registry.
All this does is create probation.
I don't think we have a first offender exception in the sex offender
No,
registry.
we do
as
not.
we
We do not. We do not.
So you have to tie in the language there.
Thank you, Mr. Chairman. Okay, just if you explain this for me again. We accepted this amendment because I have been urging us to, under those limited circumstances when they might give a probation, to change having them put on the sexual offender registry for the rest of their life. But what I hear you saying is, and see if I'm correct, that this would be, and those were very limited circumstances that probation might even be possible, right? Okay. And they weren't the most horrendous offenders. But if we accepted this amendment, then we would be giving first this possible exception to really horrendous.
Well, as I understand it, and just hearing the amendment, and I'll let Representative Mumford speak to his own amendment, but again, this is only for persons under the age of 21.
That's correct. It restores, the intent of the amendment is to restore first offender treatment
To persons under 21.
Regardless.
In the discretion of the court.
Yep. So what this amendment would do is would give the court full discretion on persons under age 21, regardless, and you're absolutely correct, Chairman Cooper, of the circumstances.
Okay. I have concerns with have serious concerns with that. I know you've been kind enough to say that you talked to me about the other, but I have serious concerns. Even somebody that's 21 years of age having that kind of blanket. Sorry, Chuck.
Okay, for any further questions about the Mumford Amendment that's on, I'm sorry, Representative Bearden had a...
It is pressed. I'm ahead of schedule. Before I accept or agree or object to this motion, let me get this clear. A 20-year-old rapes a 13-year-old. Under the court's discretion, if the court allows first offender status, and basically this 20-year-old is now going to escape the 25-year minimum that he's looking at, or would be looking at.
Yes, this is a first offender clause that would be like every other first offender case. It's in the discretion of the court, and upon recommendation of the district attorney, setting up whatever the parameters of it are.
Excuse me, if I might, Mr. Mumford, I'm not sure you heard the question. He used rape as an example, and I don't think that would be covered. The only offenses that would be subject to Mr. Mumford's amendment would be 2 through 8 in subsection A of New 6.2, and rape would not be one of those.
But one of those you just mentioned would be a 25-year sentence, though, correct?
That is correct.
So what we're saying is we're letting these folks go on a first offender shot, and we're trying to get tough on them on that 25 years, that they could go under first offender, and then possibly, while they're doing their routine, they could go out and rape another 13 or commit another offense that would be a 25-year offense. So that's where my problem be coming at on. We're getting tough on these people. Let's get tough on them.
Okay. Are you finished?
Until it's time to object to it.
Okay. Chairman Knox, did you have? Okay. Representative Mangum.
The 7 deadly sins, rape is one of those. I thought that was treated differently.
I did too.
Okay, so I
You addressing this to me?
Yes. Well, I thought 2 through 8, aggravated assault, false imprisonment, sodomy, all those things. Is that what your amendment would apply to, or are you trying to overrule and override the 7 deadly sins?
No, I'm trying to, I agree that I want to accept murder and rape. And on robbery,
does your amendment, as it is currently crafted, exclude rape and murder? That's a better way to ask it, because I think rape and murder, I don't think they should get first offender treatment, and I want to make sure that your amendment is crafted so that rape and murder are excluded. And so, if we need to, can legislative council add any light on how to prevent it so that it is?
Representative Mangum, could council choose?
I think, and we can. I think that the amendment only addresses the non-7 deadly sin crimes that we're taking care of in the new sentencing provision, and this would not have an impact on the existing sentencing under 17-10-6.1, which specifically excludes first offender treatment or probation. We're not changing that, and I don't believe this amendment would do that as presented by Representative Mumford.
I asked that question because my good friend, who is in law enforcement, who raised that issue about rape, I want him to feel comfortable that we agree on something.
We agree on 4 things, but it's just the other one's the trauma session,
Now that.
child and sexual assault. Yeah, we need to definitely work on
May I use my cell phone, Mr. Chairman? I'm supposed to speak in 15 minutes at dinner, and I need to let them know I'll do it.
All right. Now, Chairman, Representative Mangum, I didn't mean to.
So am I to understand that 7 deadly sins are still the 7 deadly sins?
Yes, sir.
Okay. So, in other words, rape, the example that my colleague gave, would not be covered by the amendment that for first offender treatment,
by the amendment that Representative Munford is proposing.
That's correct, in my opinion.
Okay. And just so that, with all due respect, Mr. Chairman, I know that council is going to agree with him, but I just want her to shake her head up and down, or I need to go and study it. Because, okay, she shakes her head, so.
I checked with her before I answered, Representative.
Because my friend, I love agreeing with my friend on things. So I want to just make sure that. Thank you.
Okay, now we're still on questions on the Mumford Amendment. Chairman Knox, did you want to be recognized? Okay. All right, Chairman Bordeaux.
Thank you, Mr. Chairman. If I could ask a question of the author of the amendment. Mr. Mumford, if first offender treatment is given under your amendment to, say, child molestation, what is the possible punishment sentence that the judge can levy?
I probably have to defer to Mr. Choate. I think currently it's 1 to 20, and I don't know whether it changes to 25 to 50.
Does it at least keep the current punishment?
It raises it. I believe it's 5 to 20, Mr. Mumford.
Right. No, it doesn't.
No.
Whatever the sentence is, it is.
It doesn't alter that at all.
They would still be going to prison.
It could,
Whatever the sentence
whatever the sentence is.
Sure. Okay. All right. Thank you.
Okay. All right. Further questions on the Mumford Amendment? If not, is there objection? I'm sorry? We have an objection. All right. Do you move?
I move.
All right. The proposition before the committee now is on the adoption of the Mumford Amendment that we have thoroughly discussed. All in favor of the Mumford Amendment, please indicate by raising your right hand. 6, 7 in the affirmative. All opposed, raise your right hand. I count 6. The amendment has been adopted. Any questions? All right. Did you wish?
I have another amendment. If you want to go to somebody else, you can.
All right. He has it. All right. Mr. Mumford has one more amendment, but he needs a moment to regroup. After he's got it. Recognize Vice Chairman Mumford.
Question to the Majority Leader. Page 34 on 2137S, line 12.3.
What page?
I'm just curious about this prohibition from seeking election to the local Board of Education.
Can you give me that reference again, please, Representative?
Page 34, line 12. Can you?
That's current code, if I believe.
Mr. Choate, do you think that's constitutional?
It's in code now.
I believe it is.
You do?
It would be an impediment on a convicted felon. I think the legislature's it doesn't.
That's what I can't figure out. I mean, I just don't understand. I mean, a convicted felon can be elected certain places in the state, can't he?
I think the court is. No, that's not correct.
That's not correct.
No. I think that this deals with the judge's ability to probate someone, and the sense is that we probably would not want a probated convicted sex offender running for the Board of Education because that would mandate interchange with students. So I believe that was the sense of the Senate amendment last year, and I can't come up with any other rationale for it than that. And I can't think of why it would be unconstitutional, so therefore I think it would be constitutional.
is it your position that you want it to remain there just to not disturb the sentence? Whoever put this in last year, I see the majority leader shaking his head.
It's my intention, yes, for it to stay in there, not just so it doesn't disturb the Senate. As you know, some days I get great delight in disturbing the Senate. But it's there because I think it's good law. And I'm not so sure that I want someone who's convicted of sexual offenses against our children setting educational policy for our children.
All right, but does that mean you can run for the state school board?
I don't know what the code is, but I think the state school board is appointed, not elected.
That's right.
Is there an amendment on the floor?
No, I'm not going to amend on that.
Okay. Chairman Franklin.
That was from prior one.
Okay. Further amendments. Further amendments. I'm sorry. Yeah, we have two of Mr. Keene's at some point. If someone wants to move those. Chairman Bordeaux.
Thank you, Mr. Chairman. On page 24, line 17, simply move the word current from in front of fingerprint and put it in front of photograph where I think it belongs. Fingerprints aren't going to change the photograph issue on the current photo.
I'm sorry. I mean, Ms.
Page
Bordeaux.
24, line 17, delete current where it is and put it in front of photograph.
So you'd have current fingerprints and a current photograph?
No, sir. Obtain fingerprints and a current photograph of the sexual offender. I presume the fingerprints aren't going to change, the photograph is.
Good catch.
Does everyone understand that amendment? Any question? Is there any objection to the Bordeaux amendment? Hearing none, it stands adopted. Chairman Franklin, did you wish to be recognized?
If I may, have we adopted the AM 290449 as amended by numerous amendments?
No.
I'd like to move that, unless someone wants to try to amend some more, I'd like to move that we adopt AM 290449 as amended.
Is there a second? Have a move and a second that AM 290449 be adopted as an amendment with the amendments that we have approved here tonight. Any discussion on that motion? Hearing none, all in favor indicate by raising your right hand. Any opposed? My count was 10 affirmative and 1 negative. Tim, if you would reflect that. And also reflect earlier, I don't know that I announced a numerical breakdown. It was 7 for the Mumford amendment and 6 in the negative. Be sure we have that. All right, so we have now adopted AM 290449. We've adopted that amendment as amended. Further amendments. Vice Chairman Mumford.
I'd like to inquire with the council.
Which one?
With,
a room full of them.
If the section that you just pointed out to me was altered to say that no person over the age of 21, would that meet your objection to it?
Well,
under the age of 21.
yeah, I think with your amendment, I'm not sure that that's necessary, that language. And part of my difficulty in answering your question is that I don't have the words of the amendment in front of me, so I can't talk directly to the council.
We didn't adopt that. Did we adopt that? Another Keene amendment.
was I'm under the impression that we all did know that there were some things that were taken care of, but there's still a few issues that are not.
Mr. Chairman, may I make a motion to come over here to?
It probably would be a better motion.
Right.
You're recognized.
In Amendment 290449, which we just adopted, there is a clause at line 26 which states, "No person convicted of a sexual offense shall be sentenced as a first offender pursuant to Article 3 of Chapter 8 of Title 42, relating to probation for first offenders or any other provision of Georgia law relating to the sentencing of first offenders." We would like to add in, after the word sexual offense in line 27, the words "except as provided in subsection E of this code section," which is the Mumford Amendment that was previously passed by this committee.
I thought that was subsection G.
No, it's E.
He said he was.
Okay. Okay. Does everyone understand that amendment to AM 290449, which has already been adopted as an amendment as amended?
Again, that only relates to persons under 21 years of age.
Which is what subsection E says.
Right.
Jill, you have the language down?
I have that one.
Right, okay. Is there objection to that Mumford amendment? Hearing none, that one is adopted. Did we, Mr. Leader and Mr. Choate, did we adopt AM 290443?
No, sir, Mr. Chairman.
No, sir.
Chairman Franklin.
I'd like to move that we adopt Amendment AM 290443.
Is there objection? Hearing none, that amendment will stand adopted. Chairman Franklin.
At the proper time, I'd like to make that.
Okay, well, there's already got a hand up, but I'll recognize you for participation in that. Further amendments from members of the committee. Chair recognizes Representative Bearden.
Thank you, Mr. Chair. I'd like to make a motion that this bill do pass as amended, this committee.
By substitute?
By substitute, sorry.
Second.
We have a motion that House Bill 1059 be given a favorable recommendation by this committee, by committee sub, as amended. Is there discussion on the motion? All in favor of the motion, please indicate by raising your right hand. Representative Mangum, I'm being patient while you make up your mind.
My friend raised his hand.
4, 5, 6, 7, 8, 11. All opposed? The vote is 11 in the affirmative and 2 in the negative. That will be recorded, and this bill will be passed on to the Rules Committee with a favorable recommendation. Recognize the Majority Leader.
Thank you, Mr. Chairman. I just want to thank you, first of all, personally, for your patience, your work, your efforts. Ladies and gentlemen of the committee, thank you. I know how arduous this process has been, but I think today we've taken the first step to help protecting our children from these type of people, and I'm very grateful to each of you. Thank you, Mr. Chairman.
Well, I thanked a lot of people earlier, and I want to save the best for last, and that's my committee. And I want to thank y'all for your hard work and being here on what has been a very complex piece of legislation. Thank all of you. This meeting is adjourned, and I think we reconvene tomorrow, and we're not going to